On December 16, 2014, the Provisional Federal Rules under the Family Homes on Reserves and Matrimonial Interests or Rights Act, also referred to as FIRMERA, came into effect. These rules may not apply to every First Nation. Some First Nations manage their lands under the First Nations Land Management Act, while others have self-governing agreements or have already enacted their own MRP law under the Family Homes on Reserves and Matrimonial Interests or Rights Act. It is important that you determine which rules apply to your First Nation. The Provisional Federal Rules cover a wide range of issues around on-reserve matrimonial real property in the event of a marriage breakdown or death. What is matrimonial real property? Essentially, it is the land held by one or both spouses or common law partners and used by the family. It can include houses, sheds, and any other property attached to this land. This is also referred to as the family home. Property is very important to families, communities, and governments. As a lands manager, it is fundamental to ensure compliance with existing real property legislation. With this law, there are forms and procedures that First Nations are required to fill out when registering documents in the Indian Land Registry System, or ILRS. As a lands manager, it would be valuable to make it clear to those wishing to register a land transaction that if they are an individual or a corporation solely owned by an individual and they wish to complete a land transaction, such as a land transfer, lease, assignment, sublease requiring ministerial approval, permit or mortgage requiring ministerial approval, that affects real property on a reserve, there are 5 forms that relate to these kinds of transactions. Let's take a quick look at each form. This will help you understand which one applies to your situation and help you make informed decisions on behalf of First Nations communities operating under the Provisional Federal Rules of the Act. The first form is called the Assessment of Matrimonial Real Property and Statutory Declaration. Always start with this form, unless you are an executor of a will or the administrator of an estate. This form is used by an individual who holds an interest in land on a reserve and wants to complete a land transaction. The second form is the Statutory Declaration of Spouse or Common Law Partner. This form is completed by the spouse of an individual who is in lawful possession of or leases land on which the family home is situated and where the spouse is consenting to the proposed transaction. The third form is the Statutory Declaration of Executor of a Will or Administrator of an Estate. This form is filled out by an executor or administrator of the estate of a deceased First Nation member who died on or after December 16, 2014. The fourth form is called the Statutory Declaration of Executor of a Will or Administrator of an Estate who is also the surviving spouse or common law partner. It is filled out by a surviving spouse who is also the executor or administrator of the estate of a deceased First Nation member. The fifth form is the Statutory Declaration of Surviving Spouse or Common Law Partner. This form is used to obtain the consent of a surviving spouse to the distribution of real property held by the deceased. There is one other form worth mentioning. It is called the Transfer of a Right to Possession of Reserve Land by Court Order under the Family Homes on Reserves and Matrimonial Interests or Rights Act. We'll only focus on the first 5 forms, as this form is to be completed by INAC and not by the First Nation. While the INAC Regional Estates Officer is the primary contact for executors or administrators, members acting in this capacity may contact the First Nation Lands Manager to assist them in completing the necessary forms. If you are a lands manager, when you register a land transaction document, it is important to understand that you must submit either an assessment of matrimonial real property and statutory declaration, or a statutory declaration of executor of a will or administrator of an estate. Now that you know the specific types of MRP forms that exist, let's take a closer look at each form, along with some helpful tips for their completion. The purpose of the Assessment of Matrimonial Real Property and Statutory Declaration is to establish whether the interest in a family home is encumbered by a proposed transaction. It also determines if the consent of a spouse or common law partner is needed to proceed with a land transaction. As a lands manager, you must obtain this declaration from an applicant and ensure that they are aware that the provisional federal rules may impact their proposed transaction. You may be filling out this form or may simply be assisting the applicant to do so. Beginning with Section A, fill out the legal land description. It can be found on the Certificate of Possession, the land transaction document, or on the parcel abstract report generated through the ILRS website. The personal information in Section B includes the name, Indian registration number, if applicable, and city or town and province of the applicant. Then, the applicant checks the applicable boxes in questions 1 through 6. The answers to statements 1 through 6 will determine the next steps. If neither the spouse nor common law partner is a First Nation member or Indian, the legislation does not apply. They would check No to Statement 1. If, however, the applicant or their spouse or common law partner is a First Nation member or Indian, they would continue to Question 2 to indicate if they are married or in a common law relationship. If they are, Question 3 confirms whether or not the family home is situated on the subject lands. If it is, and no legally binding domestic contract has been entered into, the consent of the spouse is required in the form of a statutory declaration of spouse or common law partner. The applicant signs the completed form in front of a Commissioner of Oaths. The Commissioner of Oaths then completes the declaration, witnesses the signature, and affixes a seal. First Nations generally have a staff member who is a Commissioner of Oaths. If any court orders have been made under the Family Homes Act with respect to the property, they must be attached to the assessment, along with a land transaction document and spousal consent form, if applicable. All of these forms are then submitted to INAC for registration in the ILRS in accordance with Indian Land's Registration Manual and Land Management Manual procedures. The statutory declaration of spouse or common law partner is used to obtain that partner's consent before going ahead with a transaction that involves land on which the family home is situated. If the person has a spouse and a common law partner, this form must be completed by both. Beginning with Section A, fill out the legal land description. It can be found on the Certificate of Possession, the land transaction document, or on the parcel abstract report generated through the ILRS website. In Section B, the personal information must be completed by the spouse or common law partner. First, they fill in their name, Indian registration number if applicable, and the city or town and province where they reside. Then, they complete questions 1, 2, 5, and 6, since we have determined through question 3 of the assessment that the family home is located on the property. In the declaration section, the declarant is the spouse or common law partner. After reading and agreeing to questions 1 through 6, they must sign the statutory declaration. This provides their free and informed consent to the transaction relating to the property on which their family home is located. A Commissioner of Oaths then completes the declaration, witnesses the signature, and affixes a seal. This form should accompany the land transaction document being registered, along with the assessment of matrimonial real property and statutory declaration. These documents should be filed according to the procedures laid out by the Land Management Manual and Indian Lands Registration Manual. The statutory declaration of executor of a will or administrator of an estate is used by an executor or administrator to confirm that a surviving spouse or a common law partner has an interest in a family home. This form helps to determine whether or not spousal consent is required and only applies to the estate of someone who died on or after December 16, 2014, and who held real property on a reserve. In relation to the matrimonial real property, the surviving spouse or common law partner will have to choose between receiving an amount or right under the Family Homes on Reserves and Matrimonial Interests or Rights Act, or an amount under the will, or, if there is no will, the intestacy provisions of the Indian Act. An executor or administrator cannot distribute this person's real property until one of the following has happened. A survivor consents to the distribution, or an application is made under subsection 36(1) and any resulting orders have been disposed of, or 10 months has elapsed, including any court-ordered extensions, and no application has been made in that time. Beginning with Section A, fill out the legal land description. It can be found on the Certificate of Possession, Land Transaction Document, or on the Parcel Abstract Report generated through the ILRS website. The personal information in Section B is completed by the executor or administrator, who fills out their own name and the city or town and province where they live. Then, they complete questions 1 and 2 and check the applicable boxes in 4 and 5. If the box in question 4A has been checked, then consent must be provided in the form of a completed statutory declaration of surviving spouse or common law partner. If 4B has been checked, consent is not required. The applicant must choose between 4B 1, 2, or 3 to identify why consent is not required and must provide copies of any applicable orders. The executor of the will or administrator of the estate is the declarant. They must sign the statutory declaration, having read and answered questions 1 through 5 in Section B. A Commissioner of Oaths then completes the declaration, witnesses the signature, and affixes a seal. The completed statutory declaration must accompany the land transaction document that the executor or administrator is submitting to the Regional Estates Officer at INAC, along with a statutory declaration of surviving spouse or common law partner, if applicable. The executor or administrator should also keep a copy of the package for their own records. A statutory declaration of executor of a will or administrator of an estate who is also the surviving spouse or common law partner is used by a surviving spouse or common law partner who is also the executor or administrator and who wants to distribute the estate of a deceased First Nation member who died on or after December 16, 2014. The executor or administrator cannot distribute the estate until a survivor consents to the distribution, or an application is made under subsection 36(1) of FIRMERA, and any resulting orders have been disposed of, or 10 months has elapsed, including any court-ordered extensions, and no application has been made in that time. The Indian Act and Family Homes on Reserves and Matrimonial Interests or Rights Act must be observed when completing this form. An executor or administrator who is also the surviving spouse or common law partner is the person who fills out this form. Beginning with Section A, fill out the legal land description. It can be found on the Certificate of Possession, Land Transaction Document, or on the Parcel Abstract Report generated through the ILRS website. Next, they complete the personal information in Section B, filling out their name and the city or town and province where they live. Then, they answer questions 1, 2, 4, and 5, and check boxes 6 through 8 if applicable. If the executor or administrator checks No for question 6, the other survivor must also complete the statutory declaration of surviving spouse or common law partner. The executor or administrator signs the statutory declaration, having read and answered questions 1 through 8 in Section B. A Commissioner of Oaths completes the declaration, witnesses the signature, and affixes a seal. If question 8 was answered with a yes, then a court order must accompany this form when it is submitted to the Regional Estates Officer at INAC. The executor or administrator should also keep a copy for their own records. A statutory declaration of surviving spouse or common law partner is used when a spouse or common law partner whose partner died on or after December 16, 2014, may have an interest in a family home and is giving consent to a land transaction. The executor of the will or the administrator of the estate completes this form in consultation with the applicant, who is the surviving spouse or common law partner. Beginning with Section A, fill out the legal land description. It can be found on the Certificate of Possession, Land Transaction Document, or on the Parcel Abstract Report generated through the ILRS website. When completing the personal information in Section B, the executor or administrator fills out the name, Indian registration number, and city or town and province of the applicant. The surviving spouse or common law partner then fills in all the required information in questions 1, 2, and 5, and checks the appropriate box in question 4. If question 4 was answered with a yes, then a court order must accompany this form. The applicant signs the statutory declaration, having read and answered questions 1 through 5 in Section B. A Commissioner of Oaths completes the declaration, witnesses the signature, and affixes a seal. This completed form must be accompanied by one of 2 documents: either a statutory declaration of executor of a will or administrator of an estate who is also the surviving spouse or common law partner, or a statutory declaration of executor of a will or administrator of an estate. All of these documents, including the land transaction document, are then submitted to the INAC Regional Estates Officer for registration in ILRS. It is always a good practice for the executor or administrator to keep a copy of the package for their own records. The forms and procedures set out in this video are subject to evolving public policy, legislative changes, and case law. Registration and estates processes may also vary somewhat from region to region. This makes it essential for every lands manager to have a comprehensive understanding of the principles of the Family Homes on Reserves and Matrimonial Interests or Rights Act. By staying in touch with your INAC Lands Officer and INAC Estates Officer, as well as the Center of Excellence for Matrimonial Real Property, you as a lands manager will be better equipped when carrying out your important administrative duties. We hope to hear from you soon. In good spirit.